All right. Well, good afternoon. I'm here today with Honorable Judge Lawton Stevens, and my name is Nyonnohweah Seekie. We're conducting an interview for the Seeking Equal Justice and Addressing Racism and Racial Bias Committee. So I'm going to go ahead and just get started, get straight into the questions. Just Judge Stevens, thank you for joining me today and for participating in this interview.
Well, thank you so much. I appreciate being asked to do it.
I want to start with just a little bit of background, so that everyone can get to know you. Where did you grow up? Where are you originally from?
Well, I was born right here in Athens, Georgia, and there's no place better to live. You know, I'm here on a Friday afternoon of a football home game, so it's a great place to live. But I had sort of an unusual upbringing because when I was 6 years old, my father was elected to Congress. And so we would spend 6 months in Georgia and 6 months in the Washington, D.C. area following him. And so I was in the 8th grade before I actually had ever gone to the same school the whole year.
Oh,
so,
wow.
So I grew up in Athens and sort of in between Athens and the Washington, D.C. area.
Okay. I'm partial because I grew up in DC. That's where my family was
Is
originally
that
from.
right?
Yes, before we moved to Georgia.
Yeah, well, we lived in Alexandria, Virginia. We lived in McLean, Virginia, and then right before about the last 8 years of my dad's service in the Congress, he lived on the Methodist building right across the street from the U.S. Supreme Court. So it was
Oh,
it was
wow.
a great experience. He
Yeah.
was there for 16 years, so yeah, I got to go back and forth. But I always wanted to come back to Athens. I always knew I wanted to come back here and live, and I'm glad I'm here.
Did you observing him involved in the legislature, did that motivate you to enter the legal field?
It really did. He was an attorney. In fact, he was on the prosecution staff at the Nuremberg trials because he had was in the Army. He had done an exchange year from the University of Georgia in Germany. He spoke fluent German, and I was always impressed by the fact that he was part of the prosecution staff at the Nuremberg trials, and then he practiced law in Georgia before he became a congressman. So I'd say he probably had a really big impact on my decision to enter the legal field.
Okay. And then being originally from Athens, I know that you attended UGA for law school. So was it always a plan to go there for law school?
It was. I had gone to University of North Carolina and graduated from there, undergraduate, and then I was ready to come back home. And the fact that my father was a congressman had a lot to do with my being accepted into the University of Georgia. I was fortunate at that time to have been accepted. And so, I made some great friends there. It's a great institution and getting better and better. So I'm glad I went when I did because it is extremely competitive as far as the entrance requirements now. But I'm always proud to support the law school and proud to have been a graduate of the University of Georgia Law School.
And I know you've, gone and spoken at the law school since then. And so what was the environment like and what are some of the, changes that you've seen since then?
Yeah. Well, it was extremely competitive. These were a lot of, with the exception of myself, these were highly intelligent, highly motivated persons in the law school. It was sort of intimidating. The academic rigors were extremely challenging. I did the best I could. I was not a great academic achiever at that time. But it was sort of a wake-up call for me because it was the most challenging academic experience I'd ever had. Mm-hmm. And I was challenged to learn a new language, to learn the language of the legal profession. And I've made so many friends that I have continued to make, that I've continued to stay in touch with. Mm-hmm. One of my classmates, Beverly Martin, who rose, she's one of the stars of our class, rose to the 11th Circuit Court of Appeals. Pat O'Connor, who was the president of the state bar, So I've made some lifelong friendships there, and those relationships are what I remember the most.
As far as, how, is there anything that you've observed there now, and going back to the university that you've seen that's, very different or that's, changed significantly?
Yeah, I would say that certainly the faculty and the student body is more diverse now than they were in 1978 when I arrived.
Mhm.
I think in my graduating class of 1981, there were I believe there were 7 African Americans that were my classmates in 1981. So there's much more diversity in the faculty
Okay.
and the student body, and of course their stature in the legal community and among other law schools nationally and internationally has just gone sky high. So the reputation of the school has certainly been enhanced. We've had great leadership, great deans that have served the law school. Bo Rutledge, I don't think you're going to find a better dean of anywhere than Dean Rutledge. Dean Shipley was such a great ambassador for the law school. So yeah, I think it's just the fact that it's risen so precipitously in the ranks of other law schools is a major change.
Definitely.
Yeah,
Now, after you graduated, you went into private practice.
that's right. I practiced law for 10 years, and I was, I guess, a street lawyer, I could say. I did domestic relations. I did a little bit a good bit of criminal defense work. I did some personal injury work, and I had practiced with 2 different law firms, and then I practiced with my father for 3 years. And he came back. I think he was 70, like 80 years old, and decided he wanted to get back into the practice of law.
Oh, wow.
We practiced law together for 3 years, and that was my favorite experience, was going, trying cases next to him and just, benefiting from his experience. Of course, I was trying to build my practice, and he had a lot of contacts, and we had a lot of fun together. And that's really my favorite time of practicing law, was the 3 years I spent. We had business cards, Stevens and Stevens, and I always said, I'm the first Stevens and you're the second Stevens. And he said, no, I'm the first Stevens and you're the second Stevens. But yeah, that was, and it was a great experience. Also, I served in the state legislature for 5 years while I was practicing law. And he had been in the state legislature, state house, and state senate. So, I had the challenges of trying to make a living and still participate as a representative. So, yeah, it was great. I enjoyed practice.
Yes, it definitely sounds as though, especially, having so much experience across various fields of the law,
Right.
you definitely learn a lot.
And my friend Paul Kurtz at the law school, he and I are still friends. He was the first professor I met when I came to the law school. I took domestic relations from him. I took criminal law from him, and who would have known that I would have done domestic relations and criminal pretty much all the time, not only as a lawyer, but also as a judge. So I've got a lot of experience in those 2 fields for sure.
Yeah.
Yeah.
Now, you mentioned serving in the House of Representatives.
Yeah.
Were you involved in any committees?
I was.
Okay.
I was on the Special Judiciary Committee when I first got there, and then later on I had the benefit of being on the Judiciary Committee, and that was really where the action is, and it's still the Judiciary Committee, and of course now they've divided it into civil judiciary and the judiciary criminal. But the Judiciary Committee was really where all the major bills came through to, that had to do with criminal justice, civil justice, and the judiciary. And so that was a great experience. But my favorite part about being in the legislature was I got to sit next to Michael Thurman. He and I went in the same year in 1986, and we were still great friends. And he was just a leader in state politics, and somebody that I consider a confidant, and we had a good time up there the 5 years that I was in the legislature. One thing I forgot to mention, I think you talked about what changes have occurred, and since the time I was in law school and started my practice.
Yeah.
And of course, the first thing that comes to my mind is technology, because if you look behind me, all these books, all we had back when I was in law school and when I first started practicing law, we had books. We didn't have the computers. We didn't have the technology that they have now. And if you wanted an up-to-date case, if you were able to cite a case to a judge that was less than 2 years old, well, you were right on top of things. And nowadays, if you hadn't looked at the Fulton Daily Report this morning, or checked the Supreme Court website, man, you're 20 minutes ago. You're out of luck.
Yeah.
And just the speed at which the information travels. Because if I were, in back in the day, we did a lot of negotiating if we're trying to settle a case. If it was let's say it was a personal injury case, and you'd write a letter and say, here's what my client wants, and you'd wait for the letter to be responded to, and then you'd send another letter, and it was weeks before things got finished up. So, but nowadays it's like just all electronic. And the other thing that's a change is when you think about when I first started practicing law, there were like 5 million people in Georgia. The population of Georgia was about like 5 million. Now it's like 11 million.
Yeah.
So it's more than doubled. And so just the caseload, the volume, the different types of cases, and the communications, I mean, it really has sped up considerably.
Yeah.
Mostly because of the technology.
Do you think that technology is, is assisting with that growth of the population?
Absolutely. I mean, there's no way. Like, we got e-filing now. I mean, if I had to carry every file with me to look at to see if somebody filed an answer, to see if somebody filed a motion, now, with this a few strokes of the keyboard, I can tell whether or not an answer's been filed. I can tell whether a motion's been filed, whether somebody's been served with process. So it just makes it considerably easier. And one thing that I thought about was that, some lawyers, old school lawyers and judges like me say, well, in my day, we could settle a case with a handshake. We could settle a case over the telephone, and we didn't have to confirm and write and say, confirming our previous conversation. And, that may be true, but there's still cases that you can do that. If you have developed trust with another attorney, if you have experience with another attorney, if you know that this attorney is a person of their word, then you can still do that. So it hasn't changed as far as the collegiality and being able to settle cases and being able to rely upon the word of a lawyer you trust. But even back then, there were certain lawyers that you couldn't rely upon a handshake. You couldn't rely upon a telephone call. So to that extent, it hasn't changed in that regard, in my opinion.
Yeah.
Of course, I hadn't practiced law in 30 years. When I first got on the bench, I said, well, I'm going to always remember what it was like to be a practicing attorney. And then after about 2 weeks, I'd completely forgotten what it was like. So I still have to remind myself that it's, I do think that the lawyers have a harder job. In my own personal opinion, practicing law is more stressful than being a judge, although there's a lot of stress associated with my job because I'm trying to make the right decision, particularly if you're making a decision about custody of a child or something of that nature, sentencing of someone who's been convicted. So there's a lot of stress, but I don't get phone calls at home from clients complaining. I don't have to track down witnesses. I don't have to schedule depositions. There are certain things that go along with the practice of law that are more stressful than what a judge has to do. I just have to keep my caseload moving and keep cases moving and be decisive. So
Well, how did you handle some of those stresses, when you were in practice? Or what would you
Yeah.
say now in viewing it from the bench?
Well, that's a really good question. But you just had to just sort of have a next case mentality, because if you lost a case, if you maybe you got a verdict against you in a jury trial, judge ruled against you, you can't dwell on it. You just think about, well, what could I have done differently, and then you move on. And so that's really the kind of mentality that I had to develop as a judge, and that is, well, I may have made an error. Maybe I should have done this. Maybe I sentenced too harshly. Maybe I sentenced too leniently. Maybe I should have given, more more credence to what the father said in the custody case. But you can't dwell on it, because there's so many other cases that you have to resolve. And if you look at the law, the profession of law as being a problem-solving profession, people just need a decision so they can move on with their lives, and that's true with being a judge. You just make the decision, and they can move on with their lives. It's the uncertainty that really causes stress for people that have cases in front of the courts.
That's true.
So I try to rule as fast as I can, but still be fair
Yeah.
to the extent possible. But yeah, my experience in the legislature, it was extremely valuable in my practice of law, because I made a lot of contacts. Ultimately had a lot of business referrals because of my affiliation with the legislature. And there were a good number of lawyers in the legislature at the time that I was there. Denny Groover, for one, a great, just a legendary legislator who served on the Judiciary Committee when I was there. And we had whenever a bill came through, it never made it out of the committee unless it had been Grooverized, because Mr. Groover was just a brilliant attorney. He actually was during World War II, had been part of the Black Sheep Squadron with Pappy Boyington, and flew combat. I guess he was with the Black Sheep Squadron, and was in the Pacific. But he flew these combat missions, and it was in terrible conflicts there during the war. And so he had the respect of everyone because of that experience, but he was also a brilliant lawyer. And if a bill hadn't been Grooverized, it wasn't going anywhere. So he was one of my mentors, I guess you could say. As was my chairman, Billy Randall, when I was on Special Judiciary. Billy Randall was a great chair of that committee, and I learned a lot from him as well.
And so following I guess my question that I have now, since you mentioned going, being on those committees, I know that you're part of several boards and organizations now, but the one that we're both involved with is the State Bar of Georgia's Seeking Equal Justice and Addressing Racism and Racial Bias Committee, which often I just say Seeking Equal Justice Committee because that's a mouthful.
Right.
Yes, yes. But I did want to ask what, influenced you in joining or becoming involved with that committee?
Yeah. Well, I was witness to the upheaval that was caused by the George Floyd case and other cases, and the Black Lives Matter movement. And I just started thinking, we judges can't be deaf to the voices of change. We gotta look at ourselves, and we gotta be part of the conversation, part of the solution. And so I thought, when Dawn formed the committee, I said, this is something I really would like to be a part of. I have been a member I've been on the Board of Governors, for maybe 15, 16 years. And this just piqued my interest because I think it's so topical. And I wanted to be part of the conversation. I wanted to really at the same time explore maybe my own implicit biases and make sure that I wasn't, you know, we talked about a lot about confirmation bias, you know, when we've had our meetings and things of that nature and courageous conversations. And I wanted to explore to make sure that maybe I didn't have these, you know, confirmation bias, that I could look at each case individually and make sure that you know, that I was sensitive to that issue. And when I started out as a young lawyer, I mean, we had female lawyers who were somewhat of an oddity at that time. There were not that many female lawyers in my area. And they would complain to me. So when I went over to this judge over in this rural circuit, and he called me little lady, or he called me lawyerette. And I'm like, you know what? You're a lawyer. You deserve the respect of judges. You deserve the respect of the community. And so, you know, when I first started, there was a lack of diversity in the legal profession in general. There was certainly a lack of diversity on the bench across the state. And when what I really remember when I was, I had been in the legislature for about 5 years. Mm-hmm. And one of my colleagues was Tyrone Brooks, and he filed a federal lawsuit. This is kind of how I got to be a judge, okay? He filed a federal lawsuit that said that the judicial circuits should have been subject to the Voting Rights Act, should have been pre-cleared by the Justice Department pursuant to the 1965 Voting Rights Act. And so every judicial circuit that was created after the 1965, because the previous circuits were considered to be grandfathered in, should have been pre-cleared. So that lawsuit was pending when Judge Barrow took senior status. And so there was going to be an election for his seat, but the elections for judges in the Superior Courts of Georgia was enjoined by the federal court. Mm-hmm. But they said that you could fill vacancies by appointment pending the resolution of the lawsuit. And so Zell Miller was the governor at that time. And the lawsuit essentially reflected the fact that there were so little people of color on the judiciary, and very few women on the judiciary at the time as well. And so Governor Miller, I happened to be in the legislature, and I happened to be a supporter of Governor Miller and voted for his legislative initiative. So I certainly had an advantage. And so I was appointed in 1991 to this position that's otherwise elected, but I didn't have to run for the first 5 years. Mm-hmm. I didn't have to run for election until 1996. But by then, Governor Miller had made so many appointments and had recognized the need for diversity, and he had done such a good job of making sure that there were representatives of all the different minority members on the bench, that the lawsuit was settled and dismissed. So I've always looked back on that and think about how that legislation that was sort of the beginning of trying to recognize we needed diversity on the bench, and having that become a reality. And I've always supported that, particularly on the appellate courts, to make sure that we have diversity on the appellate courts. Because particularly if you're dealing with the criminal justice system, and if you're talking about a trial in front of a jury of your peers, or you're talking about fairness in the court system, then people need to see other people that look like them in those positions. So if you have a segment of the population who does not trust the court system, then you need to make sure that there are people who look like them who are in the court system, so they can say, you know what, this is I can deal with this. So
Mhm.
that's something that I feel really strongly about.
Definitely.
Yeah.
And I know that you mentioned earlier about wanting to recognize any implicit biases that you may have. Do you think that that's something that's important
Yeah.
for both lawyers and judges to kind of have that reflection and education?
Oh yeah, yeah. I think so. It's one thing that I'll never forget because there's really three things that have happened in court that sort of underscore um, the fact that we need to be having these conversations.
Mhm.
And one of them was when I was on the bench and I was taking a guilty plea from a young African American male when he was charged with possession of cocaine. And his lawyer said, in an effort to litigate, he says, "Well, Judge, smoking crack is a black cultural activity." And I mean, and then this is in front of a packed courtroom. I mean, I had never, I can tell you, I've never been so mad at a lawyer to have said that than I can ever remember,
Mhm.
because it was, this is like, you're not, it's not, it is not to have that assumption
Yeah.
as a lawyer, to have that preconceived notion. I mean, that prejudice, that bias, and I let him have it. I got to tell you, I let him have it, and it's just, it was so wrong on so many different levels. But and so you have to get over that attitude. The
Yeah.
lawyers have to get over that attitude. Um, it's a fact of life, and you asked me what has changed, and since I became a judge or since I started practicing law and what's going on now, it is still a fact of life when I go into a courtroom on an arraignment day, whether it was 1991, the first day I started, or 2001 in the 30th year of my practice. I'm looking out at 80% young black males in charged with crimes. I mean,
Mhm.
that's just a fact of life.
Yeah.
And so I think, we talk about mass incarceration. We talk about alternatives to incarceration. And I think that really is where we got to go. And I'm on my soapbox now because I've been a felony drug court judge for the last 10 years. And so what we're finally starting doing with these accountability courts that are proliferating all over the state of Georgia is finding out what are the underlying problems.
Yeah.
If it's addiction, let's treat the addiction. If it's homelessness, let's treat the homelessness. If it's underemployment, let's treat that. So going to the um, underlying causes of why people get in trouble with the law, recognizing that there's a segment of the population that doesn't trust the judicial system, and dealing with that. And that's
Yeah.
what we have to do. That's why I love and support accountability courts, because we're going after the root cause of these issues, and we're coming up. And this is a change, though, because we do have a lot more alternatives to incarceration that we can use. We do have a lot more institutions that we can rely upon to help us rehabilitate folks,
Mhm.
and that's something that has happened. That's slowly but surely that we're moving in the right direction. Um, but there's still, I'll never forget. I've been a judge about 3 years, and one of my assistant district attorneys, I have to make certain that I look at each and every individual case in the criminal system. I got to
Mhm.
look at each case on its own merits and decide each case on its own, based upon the individual's the crime they have committed, convicted of, or pled, and their background and their individual circumstances. But I know from 3 years into my practice, my being on the bench, an assistant district attorney said, "Well, some guys get a white boy sentence, and a white boy sentence was a less severe sentence than the African American defendants were receiving. That was the general perception. Oh, that guy got a white boy sentence. But we get what, and it was a reflection of the mistrust of that segment of the population and the perception. And so you've got to change the perception. You've got to create trust. And I think you do that by attacking the root cause of people getting into a life of crime and being aware of it. So anyway.
No, I
asked you a short question.
That does answer my question, and that actually makes me think of brings some additional things to mind, because I served on an alternative court and was a defense attorney for alternative programs when I was in the public defender's office, and so I guess my question would be, how is there any way that towards that we could expand, or an issue that I often came across was there were people who either, didn't qualify for mental health court because their mental health was too extreme, or their record, was so severe at that point that they weren't able to get into a drug court or another alternative program. And so, what are your thoughts towards expanding those programs, or other additional things that we could do to address these underlying issues?
There's an ongoing issue with accountability courts to make sure we include more minorities, because you have to want to be in felony drug court, or treatment and accountability court, or DOI court, or parental accountability court. You got to want it. You can't demand it.
Yeah.
But you have to commit to it. And if you don't trust the system, then you're less likely to commit to it. So if I'm a criminal defense attorney and I'm out trying to, and I have a client who maybe is sort of in the revolving door of going through jail and getting out and going back in, if I'm trying to convince them that what they need to do is to go into drug court, then I've got the other added burden of saying, you're going to be treated fairly. And so that requires that you trust the system. And if you've grown up with a mistrust of the system, and I had to educate myself, when I first got to be a judge, if a young man would come up in front of me and I'd say, are you so-and-so? Yeah. And I'd be like, hey, this guy's, he's not saying yes, sir. He's not saying yes, your honor. And then I had to realize that nobody ever told him that he had to. Nobody ever told him that. His pants are down. I said, golly, look at that. Nobody ever said, pull up your pants, stand straight up. There are certain individuals who don't have the same family background that I had. And so I had to say, I've got to understand where they're coming from.
Yeah.
So when you start looking at the circumstances, and then that helps you understand the whole person, it helps you kind of mold hopefully a plan to help them succeed. But yeah, we have had, it does come up even at the national level, National Association of Drug Court Professionals, trying to find ways to make sure that the felony drug courts and other accountability courts, that we are more inclusive and that we reflect more diversity, which means we have to convince these prospective participants that they will be treated fairly and that they will benefit. So, yeah, that's a challenge.
Yeah. And I want to talk a little bit about some of that distrust that you mentioned, because and going back to what you said earlier about people expecting, kind of like a white boy sentence versus, and I've, heard the same thing even as an attorney from clients, and somewhat to some extent as an attorney from other attorneys before certain judges. And so do you think that, that this distrust exists because there is some validity to that, or at least there was some validity to that? And also going to what you said earlier about the percentages that you've seen of minorities in the courtroom representation wise.
Yeah.
Do you think that plays a factor as well?
Yeah, I mean, like I say, the number of primarily young African American males, at least based on the percentage, to me is the same. My perception is it's the same.
Mm-hmm.
The number of African American judges, the number of African American lawyers, and African American prosecutors in particular, has increased tremendously over that period of time.
Mm-hmm.
But so how do we get beyond the mistrust? You just have to have that conversation. You just have to convince them. You just have to have, when somebody's sitting in the jail, we've experienced this, and somebody brings up, hey man, you ought to think about going to see about drug court, see if you want to do that. They're like, nah, man, we've heard bad things about it. So there's convincing that needs to be going on, and it needs to come from the defense lawyers and the defense lawyers it's sort of like when it comes to going into felony drug court or an accountability court, it's like, okay, well, maybe I can get your probation and then, drug screen, this. But if you really want to get out of this whole hole that you're in, then drug court's the way you need to go.
Yeah.
You're asking them to abandon the path of least resistance and take on the challenge of doing the hard stuff. And some people aren't ready. And so sometimes it's time and time again before they're ready for it.
Mm-hmm.
So you really have to kind of make sure that people understand that we're there to help you. I mean, we're there to help you solve your problem and change your life, because, change is hard. But I feel like from having when I was coming along in Athens, Georgia, small town Athens, Georgia, in the 60s, I mean, we were separate. Our schools were essentially separate.
Mm-hmm.
Our schools became integrated when I was in maybe the 6th grade. But the side of town where the African Americans lived and the side of town where the white people lived, that was different. And so it was a slow process. And so you develop trust over the years of understanding the challenges that other people have faced, and realizing that, we're all in this together. We're all trying to do, if we should all be trying to do justice, and justice has to be in each individual case.
Yeah. As far as, I guess in effort towards that justice,
Yeah.
Sometimes there are, like you mentioned earlier with that attorney who reprimanded. Sometimes there are instances that come up and, people may not know how to address them. What advice would you have for younger lawyers who are trying to address or combat some of these issues, as well as, more senior attorneys who are in positions of, influence and power?
Well, you got to speak up, first of all. You can't be afraid of speaking up. You got to get involved with your local bar association, get involved with YLD, get involved in your civic clubs, be active in your faith community, be active in politics. You got to recognize it and expand your associations with people so that you can have the conversations. One thing that I will never forget, that I hope I never see this again, and it really did happen in a court in Athens, Clarke County, but thankfully it was 25 years ago. But it's sort of a typical situation where people's biases or prejudices come out, or their assumptions about certain things come out, that is illuminating. So we had a young African American attorney who he worked for the public defender's office. Great guy. He was representing a young white male in front of the court and was entering a plea of guilty, and the young white male was wearing a coat and tie, and the judge sentenced the young white male to, I guess it was 30 days in confinement. It was part of the plea bargain.
Mm-hmm.
And so he said, "Deputy, take the defendant into custody." And the deputy had not been paying much attention, walked up automatically and grabbed the lawyer, the black lawyer, by the collar and said, "Come on, we're going," and got halfway out of the courtroom.
Oh my goodness.
And just like, because I guess he just assumed.
Mm-hmm.
And that is where I say, I'm just, I'm not gonna, I mean, I wasn't the judge, but the judge just let him have it.
Yeah.
First of all, he was just, but then you say, well, you know what? 9 times out of 10, the person I'm taking into custody is a young African-American male. But you cannot assume that each time that the case comes up. You have to take each case up individually.
Yeah.
And but that was just so emblematic of somebody with a bias and somebody that had just assumed that, this is the way it is. And you just have to get your mind out of that gutter and think about it in a different way. And I think part of the solution is to have a committee like we have, and where we're talking about these conversations. We're talking about issues that matter to people. We're talking about the removal of monuments. We're talking about, the misapprehension of what the Black Lives Movement. People assume that it's some kind of a radical thing where you're saying Black lives mean more than anybody else's lives, but you have to consider that in context of what we're talking about.
Yeah.
That we're saying that Black lives matter also.
Yeah.
And you can't, because for so many years it was like, hey, we don't matter. We're not being heard. So that's part of what we need to. That's part of educating folks, and we're trying to do that. So
We are.
I think things are better than I have to tell you, things are a lot better than they were when I first started. I just really, I don't want to paint doom and gloom, but I feel like we have progressed as a society, and I guess particularly I'm thinking of the, sort of the world I live in, and I think we've progressed considerably, but we still have a way to go.
Yeah, no, and that's how I took it. I didn't take it to mean that you were
I know.
painting a gloom picture, but like you said, there's still much progress to be made.
Amen to that.
And I have to go back to address what you mentioned as to the 9 times out of 10 or 8 times out of 10, and that it is Black defendants or minority defendants, and I've heard more recently the statistic that only about 5% of lawyers in the United States, or 5% of the lawyers in the United States are Black, and so I kind of want to address more so that defendants number and what you think can be done about that. Is that something from a legislative aspect, or judicial aspect, or school to prison pipeline aspect, or everything, a totality of all of that?
I mean, it's all those things, and so we have the school to prison pipeline it's a real thing. So there's a lot of things that we need to do, but education, I think, is important, but the lawyers' attitudes is important as well. I'll never forget when I had the honor of being on the Chief Justice Indigent Defense Commission when Chief Justice Benham was when Justice Benham was the Chief Justice of the Georgia Supreme Court, and the commission was established to look at indigent defense. And this was in '05, so you're only talking about 15 years ago.
Yeah.
When you had contract public defenders, or law firms would take a flat rate for representing defendants regardless of how many defendants they had. You had appointed lists where people who were indigent were appointed lawyers, some of whom might have been real estate lawyers or tax
Yeah.
lawyers or whatever. And then you had like public defender offices, like what we used to have up here, the Georgia Legal Aid and Defender Society.
Mhm.
And so we did a lot of research. We had a lot of meetings, and we actually had one guy that was a public defender down in South Georgia. I think he was a contract public defender. And he actually said in one of our meetings, well, we figure most of them, like, they're all guilty anyway, so we just try to get them the best plea bargain we can get them. I'm like, wait a minute, So
Yeah.
the attitudes have to change.
Mhm.
So if you're a public defender and you got a huge caseload, you still got to do the research. You still got to take each case as it comes.
Yeah.
And I feel like we're because of the indigent defense system that we've set up, funded by the state, so that supposedly ideally mirrors the district attorney's offices, because of the adversarial nature, obviously, of the process, that we've made progress in that regard. But yeah, the lawyer, you can't get burned out if you're a practicing attorney, and by the same token, if you're a judge, you got to have the patience to listen to what's going on in your courtroom. But like you said, it's a combination of the factors. It's a recognition of the sort of the idea that there's one segment of population is overrepresented in the people that are getting arrested, and having that conversation about it, looking at it from a socioeconomic standpoint, increase in jobs, increase in opportunities, and then like we talked about before, treating the root problem with these accountability courts. So it's a combination of things. But I think we're getting closer to the solution than certainly than we were when I first started.
I certainly think so and hope so. And before we wrap up, I have a question, because you mentioned acknowledging burnout and some of
Yeah.
those symptoms right now, with COVID and certain courts,
Yeah.
closing, and juries. It is a crazy time to practice.
I'm telling
And so what are some things that, you may do or you may suggest for, just the world right now in the legal field?
Well, it's really a challenge for our accountability courts, because if you're not, we've started back meeting in person with all the safeguards for health, because part of recovery obviously is to create a community of support and a support network, which ideally is face to face. And if you are isolating yourself, either because you're in quarantine or whatever, then that's a challenge you got to overcome. It means you got to do even more to try to keep from relapsing. What you just have to be very, very cognizant of the health situation. I mean, we make sure that when people come into the courtroom, whether it's jurors or litigants or attorneys, that they're wearing a mask, they're socially distancing. We're doing a number of cases that can be done. I did a hearing yesterday on Zoom, but the lawyers were in different parts of the state. And then a lot of the cases we have bond hearings and things of that nature from the jail. We're doing that from the jail. But I feel like, and I talked to my daughter-in-law about this today, that if you just understand that it's a temporary situation. So just wear a mask, get vaccinated, do what you're supposed to do. Understand that this is not going to last forever, and then we'll come out of it eventually. But we can't, you got to trust the science. But it's thankfully with the millennials, the lawyers of your age, you've already got the technology to stay in communication.
Yeah.
So that's something that you can continue to utilize, and people like me that can turn on and off a computer and sometimes figure out how to do a Zoom meeting. That's more challenge. But yeah, I mean, I trust that the younger generation will figure out a solution on how to do that. But yeah, I mean, you just kind of have to endure until the all clear is called. Is my opinion.
Okay. And lastly, I did want to ask if they're going back to what we were discussing earlier.
Yes.
If 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 a younger attorney or newer attorney comes across an issue of whether it's prejudice or bigotry, and where there is that kind of power dynamic and it's coming from the bench, how would you is there any advice that you would have and how they should go about addressing or rectifying those situations?
Well, speaking specifically as a judge, I have responsibility over anybody who works with me. So if a bailiff does something that shouldn't be done, if a member of my staff does something that shouldn't be done, or says something inappropriate, or takes some action that shouldn't be condoned, then I need to know about it, and I need to take that disciplinary action. So if something untoward happens, if there's an example, God forbid that somebody has made an inappropriate remark or has demonstrated bias in a way that can be observed and felt by somebody, then it just needs to be brought to my attention. So if it's a lawyer that's got an issue, they need to bring it to my attention, and I'll deal with it. I mean, that's my world, as far as law practice and that, there are ways to approach it. But that would be my thought, would be just to bring it. It's just like
the judge.
Approach the judge. I try jury trials all the time, and the thing that worries me the most is that somebody's going to try to talk to one of the jurors during the trial, and if they don't tell me about it, I'm never going to know about it. And so, and I want to make sure that people that get a fair trial. And so if there's improper communication or something that's going wrong that shouldn't be going wrong, or some indication that somebody's being treated, mistreated, then I got to know about it.
Yeah. I guess my question or my concern is more so if the attorney feels as though the judge is the one treating the person, like treating a defendant wrong, and there it may be difficult for them to then approach that same judge.
That's a great question, and there we have the JQC, and you can make a complaint through the Judicial Qualifications Commission, and I assure you it'll be taken seriously if it's something that is that's of that nature and consequence. So yeah, I know they get a lot of complaints, and but they take them seriously, and they have a staff that investigates complaints. And if it's a complaint about someone who is that involves bias or prejudice or racial impropriety, then that's something that's going to be taken very seriously. Yeah, so we all know about the Judicial Qualifications Commission. We all know our duties and the Code of Judicial Conduct requires of us, and we know that the people who work for us, it is our responsibility to make sure that they are reflecting, our values to the extent that they do in their daily work. So yeah, JQC is there for exactly that purpose, and I assure you they take it seriously.
Well, Judge Stevens, I thank you so much for sitting down for us to conduct this interview. I did want to give you an opportunity if there's anything else that came to mind or that we didn't address that you wanted to say before we end.
Well, you know what? I wanted to, one thing that I left out, and I think it tells you that we've come a long way. My sister, the older of my two sisters, was at the University of Georgia with Charlene Hunter and Hamilton Holmes, and she was one that supported Charlene Hunter and Hamilton Holmes' integration of the University of Georgia. She was active in the Presbyterian Center, and they were welcoming and supportive of the integration of the University of Georgia. And she said that that she went to the federal court when there was a lawsuit filed to challenge the university's decision not to admit Charlene and Hamilton into the University of Georgia. And she said that the registrar, who was her Sunday school teacher, she went to the trial and he testified under oath in 1961 that race had no factor in their decision not to admit Charlene Hunter and Hamilton Holmes. And they were honor students. They were smarter than 2/3 of the people that were there then.
Yeah.
And she thought, you know what? She said, she said, I couldn't believe it. But she said, and then Constance Baker Motley, representing the Charlene and one of the lawyers in that, she stood up and ripped him apart.
Yeah.
And I said, well, so I guess that was the first African American, lawyer you'd ever seen. She said, I was amazed. I didn't know that women could be lawyers back then.
Yeah.
That was the first thing I thought was, golly, well, we have come a long way.
Yes.
We have come a long way. And I don't think you're going to find many judges that are going to refer to attorneys that, like some of my classmates, as lady lawyers and lawyerettes and that type of thing. So we've come a long way. Oh, well, but anyway, I enjoyed talking to you. And I was rocking back and forth, but I'm not in a rocking chair. Okay, I'm just. I'll probably look at this one day and I'll be like, he's zooming in and out,
That is not a problem. Well, thank you again. I thoroughly enjoyed our conversation and look forward to speaking with you again soon.
Absolutely. Thanks a million.
No problem. Thank
Okay,
you.
bye.
Have a good one.